Hi, everybody. I'm Tony Plahetsky. Thank you for joining us on our third day of the historic impeachment trial of Ken Paxton, the first time in more than a century that a statewide elected official has faced ouster through the impeachment process. I want to introduce our two guests for tonight. David Minton, who is a longtime attorney here in Austin from the Minton law firm, certainly a well-known name in the Austin legal community, and Justin McMinn, who operates a civil practice here in Austin, working a wide range of cases. We invited them to help debrief the day of testimony that we heard from two whistleblowers who reported allegations to the FBI concerning Ken Paxton. And David and Justin, it was really a remarkable day, I think, in many respects. David, I'll start with you. What were your sort of overall impressions? We heard today from two whistleblowers, Ryan Vassar, and continuing testimony from Ryan Bangert. Again, two executives in the AG's office. So, David, what were your impressions?
Well, I want to be measured in my comments. My recollection that the lawyer that was cross-examining Bangert was a young man by the name of Anthony Oso, and I felt like that he left himself open to some criticism that he was cutting off the witness. The witness was able to spar with him, I think, rather successfully. And I don't know that it necessarily moved the defense's case forward. I think we're very early in this. Obviously, I think the game plan is to call all of the whistleblowers. I don't see that there was anything out of the witness's testimony that necessarily helped the defense. I think that there were clearly aspects of it that were consistent with calling them as witnesses for the prosecution. But again, I want to underscore this is early, and I want to make one sort of editorial comment, is that this is a different breed of cat. This is not your normal court of law. Had I pulled some of the shenanigans that either lawyer had played during parts of this, I would have been called down and admonished. And the next time I did it, I would have probably been held in contempt. That's not this show. And so we're a long way from the end of it. And there's lots more to be said. But the second witness, I was interested in the emotion that was shown here. And that would have been, I believe, Mr. Vassar.
Vassar, yeah.
And I think that he did a good job. I think that he's still on the stand. Is that correct?
Correct. Yes, he is. Lieutenant Governor said we're going to go till about 7 o'clock tonight.
That's what I understand, and I think Mr. Little has done a good job. I think that he is has been an aggressive as Mr. Oso has been, and has done a good job for some of these things. But he is asking very specific questions about, was this a crime? Was this was this that? I'm paraphrasing, of course, and I'm not certain that witness helped him in what he hoped to get out. But again, this is so early in the game that to try to predict how any particular witness is going to impact the outcome is difficult, if not impossible, and certainly from my part on day two, stupid.
David, just want to point out to folks, Justin, we lost for a minute there, but maybe he's coming back. Justin, are you with us? See his box, but not him. David, with regard to the strategy of the attorney on cross-examination, can you just talk about we had seen repeated objections of him. Can that appear as though he's a real fighter? He's really in there. He's absolutely advocating on behalf of his client, or does he run the risk of being a turnoff to the jurors, the senators?
Let me tell you a quick war story. My father represented the Speaker of the House in the Brylab scandal. One of the lawyers is one of the best lawyers, criminal lawyers in the history of Texas, Jerry Goldstein. At a break, purportedly Gerald said, "Roy, you've sat there while they're cross-examining the Speaker of the House and did not make one single objection. When are you going to play lawyer?" And Roy turned to him and he said, "Jerry, you've spent your life defending cocaine dealers that were caught standing on the deck of a battleship full of cocaine. I am not interested in drawing this jury's attention to a question my client is prepared to answer."
Let me.
So to your point, I think it can backfire for the defense.
Here's Justin. He's back.
Tony, I had to go change computers. I don't know what was going on.
No problem. Justin, I wanted to just ask you, and sorry we lost you there, but can you just provide sort of your impressions of the testimony that we heard today, and frankly, to the extent that you're willing, the performance of the attorneys involved?
Yeah, Tony, I think you saw two very different styles today. With Rusty Hardin, he brings that old kind of country boy approach to his trials. And I think he did a really good job of, personalizing his witness. As a trial lawyer, we want our jurors to be able to relate to the witness that's on the stand, because in a way, this is about credibility. And I think he did that with Vassar, at the beginning when he had the emotional part of his testimony, and he started that off, about his background in the church. And clearly, most of these senators, at least the 9 that they're going to try to get to vote for the impeachment, they're probably very conservative Christian folks. So I think they could really relate to Vassar. I like how he kind of built that as a fundamental base at the beginning of the testimony. And I thought it was really powerful, when Vassar gave his testimony, when he was, I guess, being called a rogue, an employee at the AG, and, how that really affected him. And we saw him break down on the stand. So, watching the trial on TV, I could really kind of relate to that. On the other side, wow, the style with Oso was quite different. And also the second attorney that was there for Paxton, I don't think I ever got his name, but, it was more of an attacking style and, kind of butting in. And, some of that I agree with Mr. Minton. I think the first attorney, Oso, left some meat on the bone there. I think there's some things that they could have done a little differently. I surely would have done it a little differently as well.
Let me ask you both. I mean, the three of us each at different times and for different reasons, not infrequently, have tried to get investigative case information during the pendency of a law enforcement investigation. It has been my experience over many years, as I'm sure it is yours. The Attorney General's office, most of the time, rules in favor of a law enforcement agency not releasing information. That is their tradition. That is what they carry out in most instances. I'll ask each of you, but Justin, I'll start with you. How shocked were you? Or I guess the better question is, what was your reaction upon hearing this testimony that the AG was taking such an active role, allegedly, in trying to obtain information for Nate Paul from a criminal ongoing investigation?
Yeah, sure, Tony. I mean, in my experience, the information is never disclosed, if ever, until after an investigation is complete. I think what the House lawyers are trying to do is piece by piece build a case of all of these instances where the Attorney General has stepped in and acted on behalf that would benefit Nate Paul. So I think this is kind of one of the building blocks that's kind of a part of their case to show that, time and time again, the Attorney General has come in and done things that is out of the ordinary. I've never, in 17 years of practicing law, I've never seen the AG release information while a criminal investigation is pending. I've just never seen it.
David, how about you? What was your reaction?
Let me add to that 17 years plus 19. In 36 years, I have not, although I've tried inside baseball and the usual sources of information, and the answer is the same. If there is an active investigation, Mr. Minton, you will not receive this information. And I'm dealing with that on 2 cases today. So it is unusual in my view. And frankly, I think that is part of the prosecution that Mr. Paxton was willing to do whatever he needed to do in order to help out a friend. That's the case. And is that a part that the jury, the senators should consider in his removal? That's certainly where they're headed. And there is at least some evidence that this is extraordinarily unusual.
Can we discuss, and David, I'll continue with you on this and then go to you, Justin, but can we discuss too this assertion that the defense seems to be making of, well, all you had to do was talk to Ken Paxton, and you could have just talked to Ken Paxton before you reported him to the FBI. David, what is your position? They really seem to be driving home that point, and that this was a real break of allegiance with Ken Paxton.
Well, I'm looking at it in a couple of different ways. The first is that as somebody that is a major part of the leadership of that office, when more than one of you have gotten together and gone to a lunch where Mr. Paul is hosting the lunch and all of that sort of thing, and at least 8 of you, or at least a fair amount of you, determined that there is something wrong here. I think you've got to weigh what somebody might do if you gave them advance notice. I don't know anything about this email address, or if there were things that he could delete or not delete. But I think if there is a real concern, I don't know that I would necessarily pick up the phone and call somebody that I was fixing to contact law enforcement, and particularly individuals that I firmly believe gave a great deal of thought as to where this was going. And this was not a spur of the moment decision. I do not believe that.
Yeah, I mean, just if I'm going to report somebody to law enforcement or to human resources for improper conduct or illegal activity, to what extent, if I came to you and said, I'm concerned about these allegations, to what extent do I have to prove them up before I take them to an investigative authority? I mean, isn't that the job of the investigative authority to do an investigation based on my allegations?
Yeah, and I think that was the point Vassar was trying to get across today is, that's not his job. His job was, when they smelled something that was not right, they took it to the authority that could do the investigation. So I agree with what David says. If you have all of these things piling up, and I think, Vassar was kind of going through the 3 things, the May 20th with the release of the open records, and then the Kamek hiring, and then the foreclosure stoppage. It was just kind of an avalanche of things, and one on its own didn't warrant what they did. But as these things started to pile up, I think they're all looking at themselves like, wow, these are 3 really big things that have happened here, and they all benefit this one individual. So at that point, I think they, in my opinion, I think they did the appropriate thing, and I don't think I place any blame on him for not contacting Paxton to let him know.
Oh yeah, why not, Justin? Because the defense really seems to be drilling on that point.
Yeah, I think they're trying to paint him as a disloyal employee. They're trying to say, hey, this guy did everything for you for the last, 8-9 years that you've worked here. At the very minimum, you owed him a phone call. So I think they're trying to put that out there in front of the jurors, that this is a guy that was disloyal. He joined this group of rogue employees that, had higher ambitions, and they were trying to get rid of Ken Paxton.
David, I know you said accurately that this is early, but in this very early phase, how do you think this is all landing with the jurors at this point?
I think some of them are bored. I think some of them were briefed enough to kind of know what was coming. I think part of this is the court process, a little different from what Mr. McMinn and I are used to, but nevertheless, a court process. I think that there is going to be, here's the issue, and it's the issue that these senators are going to have to come to terms with. Is this a violation of a law or of the orderly course of business? And then, if it is, is it worthy of removal from office? And I think that that's something that I hope these folks will take seriously. If you just do the math on the initial votes on the pretrial matters, there appeared to be 6 that would just as soon this have been over on Sunday evening or Tuesday morning. And so there are some open minds. I am hopeful that those 6, despite their vote, are going to listen carefully. There is an awful lot of evidence. It's a serious allegation. And Mr. Paxton needs to be accorded its most thoughtful consideration. And you tend to lose jurors when you take what ought to be a 3-week trial and turn it into a 3-month trial. And that's not this case. But I would like to see things move a little faster. The lawyers on both sides are excellent lawyers. I've known Rusty Hardin for 40 years, and I've known Cogdell for a long time, 30 plus years. And they're and Tony and the rest of the group well represented. They need to get their point across with a little less bullying. Both not so much Rusty, a little quieter, using, as McMinn said, kind of his style. But to get it out there and move on. There are a lot of witnesses to be called, and I think we'll see things move a little faster. My suspicion is that Patrick and the senators are going to say, let's
move this along. Justin, what do you think about the fact that Ken Paxton just simply is not attending this trial? What does that say, and could it actually literally hurt his defense? I mean, it's not uncommon to see a defendant whisper something in their lawyer's ear or pass a note or compare notes during breaks and things like that.
Or body language.
Or body language, yes.
Yeah, Tony, that's a very fair question. And, at first I was thinking about it, and I didn't know, how that might benefit him from not being there. I mean, surely you want to put it out there to the public that this is something that you really care about and that you're going to show up there and defend yourself. And, one could get the opinion that, hey, this is something this guy doesn't even really care about. He's not even here for his own trial. So, yeah, it probably wouldn't be my advice as an attorney if he was my client. I would like him sitting beside me for sure. So, yeah, I don't agree with that one.
But could he literally be in a position to help his defense if he were sitting there? I mean, is it common for a defendant to whisper in your ear and say, hey, there is this thing?
I'll let David take that. He does a lot more criminal than me, but absolutely is what my.
Well, I want to be careful about the criminal side of it, but yeah, I agree with Justin. I would have had my client there. I would have coached him on. I don't need you taking a yellow pad and scribbling on it every word, but your body language. Again, I'll go back to the 6 votes. You need 4. You're being attentive. You're being a part of your defense. You being there for people to see your emotional reaction, coached as it may be. That's our job too. I think it will be to his detriment that he doesn't show up. In other words, it tells me he doesn't care. And that's the wrong message.
Well, David and Justin, thank you so much for sharing your time with us tonight and your insight with us. We really appreciate it. May come back to you during the course of this trial, depending on how long it lasts. We've said Lieutenant Governor Dan Patrick has estimated maybe 3 weeks, maybe longer. So plenty of things to discuss in the future. Thank you so much, both of you, for joining us tonight. And thank you for joining us at home. We appreciate it.
Thank you very much, Tony. Justin, good to see you.
Have a great night.
Yeah, good to see you, David.
Thank you.